Hello, I'm Bernard Starr, and welcome to this edition of Access for All. We've got a terrific show today. My guest here in the studio is Frank Askin. Frank, welcome to the show.
Well, glad to be here.
I just want to tell a few things about you. You have such incredible credentials. Frank is General Counsel for the American Civil Liberties Union.
That's correct.
Professor of Law at Rutgers University, and for over 30 years, the director of a constitutional litigation clinic at Rutgers University.
It's actually 40 years, but who's counting?
Oh, well, okay. I was hedging a bit to not tell the whole truth. Also, Frank is an author. His memoir, which is Defending Rights, A Life in Law and Politics, the politics part being that you ran for Congress, actually.
Ran for Congress a couple times, worked for a number of congressional committees off and on over the years.
Yes, I remember attending one of your fundraisers for it. I drove Mandy Patinkin.
That's right, Mandy did a fundraiser for me.
To your fundraiser. Well, Frank, you've, through your constitutional law clinic, have taken some of the landmark cases to the Supreme Court. I'm surprised you haven't had to be in a witness protection program. You've sued the Army, right? You've sued the FBI.
A couple times.
Right. You've sued the New Jersey State Police.
Absolutely.
Right. And now you're suing the President of the United States.
That's correct.
Right, trying to have the war in Iraq declared illegal as a violation of the Constitution.
That's correct.
Which many people think is true, and we wonder why the war is going on or how it happened to begin with.
Right.
So that's a very exciting issue, and we're going to get into that and focus on it. But I just want to give some of the backstory of some of the cases that you've handled and you know, how you got into this whole business, because you were actually a late bloomer. That you weren't always in, you entered law fairly late, but you were a rabble rouser going way back.
Yeah, I was a community organizer starting when I was 16 years old.
You know, what were you doing then?
In my native city of Baltimore, which was a Jim Crow city. And I was actually part of the pre-civil rights movement. This was before Brown versus Board of Education, challenging racial segregation in the city of Baltimore. So I was a community activist since I was 16 years old.
What were the things you were doing when you were 16?
Well, mostly challenging segregation in Baltimore. School segregation, recreational segregation, movie theaters, lunch counters. In those days, it was not politically correct to be for civil rights. In J. Edgar Hoover's era, it was downright subversive. So I was actually, by the time I was 18, I was on the FBI security index.
Yeah, well, you had a very early and an extended relationship with the FBI.
That's correct.
It wasn't exactly a romance.
Right.
It was a long relationship and not a friendly one for a long time.
Yeah, well, I was on the list of people who were to be rounded up in an event of national emergency and put in an intern camp. And I was on that list for 20 years, starting when I was 18. Was
that the reason why you started suing the
FBI
when you came into law?
As a matter of fact, it was certainly a motivator, because the time I went to law school, which was, I didn't start law school until I was 31 years old. In fact, in between, I was a newspaper reporter, a journalist.
Right. You worked in Baltimore.
No, I was in New York by now.
Oh, okay.
In New York and New Jersey. And when I went to law school and started learning about the First Amendment, and I began to think, where did J. Edgar Hoover ever get the right to follow me, to keep records on me? I said, it violated my First Amendment. I never did anything wrong. I never violated any laws. Why were they following me around and keeping surveillance and keeping a dossier on me? I never had that right. So that's how I first got into suing government agencies for surveilling political activists.
I remember reading in your memoir that J. Edgar Hoover, you claim, didn't go after organized crime and kind of minimize the existence of the mafia, so he could concentrate on this type of
political activists. That's what the FBI was doing in those days.
So you early on in your legal career, once you became a law professor, and started this constitutional law clinic, which dates back to 1970.
1970,
I believe.
correct.
So you've been in this business for quite a while.
Right.
But you had a number of cases in which you took on the FBI. I just want to get into just a few of them briefly to give our audience the flavor of your relationship with the FBI. I mean, earlier you defended 2 students.
Well, my favorite case was the Lori Payton case.
Lori Payton, I remember.
She was
that.
a 15-year-old high school student who, as part of a political science class, as part of her homework, had to write a letter to the Socialist Workers' Party to find out what their program was, to get brochures. So the class was called Left to Right, about the American political spectrum, and each student had to write to some fringe group. And she happened to pick the Socialist Workers' Party, which, unbeknownst to her, was under an FBI mail cover at the time, which meant that the FBI examined all incoming mail to their headquarters in New York and took out information, postmarks, and return addresses, and reported to the FBI office in Newark that there was some subversive in Morris County, New Jersey, who was writing to the Socialist Workers' Party. You better go check her out.
That's quite incredible that they were going after a student.
Well, they wind up at her high school and discover what's going on, that she had done this as a homework assignment, and the FBI agent left, but the school was a little concerned about why they were investigating one of their students. They told her parents. Her parents came to the American Civil Liberties Union in Newark, and the ACLU asked me to represent her, and so the first thing I did was write a letter to the FBI saying, why are you investigating my client, and I want any records you have on her, I want copies, and I want them destroyed. That was the start of a 7-year lawsuit because, first of all, they lied to me, denied they had been investigating her, and it took 7 years.
But you eventually did win that case.
Eventually, we won that. We got all the, finally got all the, it wasn't easy, but it was, Lori once sent me a Christmas card, said, to the most consistent man in my life after my father. We finally had the mail cover regulation declared unconstitutional. The judge ruled that the FBI had violated her First Amendment rights by conducting a field investigation based on that letter, and said she was entitled to damages from the FBI, which we settled for $1. Lori wanted to get on with her.
Well, what I find incredible about that, Frank, is that if the FBI were going after kids like this student, they must have had an enormous core of agents there involved in this kind of
That's what the FBI agents were doing. They were investigating so-called subversives. That's
the other case of Todd
was
even more incredible.
Todd was 11 years old when his brush with the FBI started. He was a very precocious 11-year-old who was compiling an encyclopedia of the world.
Yeah, that's pretty precocious at 11.
And he was writing to countries all over the world asking for information to their PR offices. And he would get letters from Eastern Europe, from the Soviet Union, from the old Czech communist government, Bulgaria, Hungary, the old communist countries, and get all these, envelopes with big stacks of papers in them. And so one day an FBI agent shows up at the family's home in Paterson, New Jersey. They want to know who's getting all this mail from these communist countries. So that was a start. This was actually
part of this was the whole hysteria about communism.
Right, sure. So anyway, but that's another long story. And
but eventually, actually, even though it was a pretty stupid investigation on the part of the FBI, you actually lost that case.
And actually, we lost. In fact, this was 10 years after my Lori Payton case, but by now the courts had changed. The courts had gotten very conservative, and we were actually suing under the Privacy Act, which actually Lori Payton helped to pass. Lori testified twice in Congress in the early 70s in support of the Privacy Act, and we were now suing under the Privacy Act for this kid Todd, but now we couldn't get to first base. The courts had turned so conservative, they never even cited the Payton opinion when the Court of Appeals finally dismissed our case. They said, well, be assured that he's done nothing wrong and there's nothing bad in his files, but we're not going to let you see them.
But it's interesting because you emphasized the change in the court, that it took a conservative turn. And what this tells us is that legal decisions or constitutional interpretations have more to do with politics than
absolutely.
with pure law or logic or reason
absolutely,
that we would like to think it's about.
I tell my students, my law students, you're not supposed to forum shop. That's part of the ethics of the practice. You don't forum. You don't look to try to pick your court.
Right.
But in my experience, particularly in litigating cases, value cases dealing with law reform, 80% of the of success is who your panel is, who your court is, your forum. So if you can find a friendly forum, that's the first thing you look for. Where are we going to find a friendly court?
So justice has a lot to do with who your friends are.
Well, that's right, and who you think will be sympathetic to your particular claim.
Yeah, I'd like to go into just one comment about the FBI, because quite ironically, after your long history, and you had other cases with the FBI and suits against the FBI, eventually, though, one of your former students, Louis Freeh, became the director of the FBI.
That's correct. In fact, I have a very nice letter from Director Freeh when I published my book, and I had sent him an invitation to my book party in Washington with an autographed copy of my book, and he sent me a very nice response. And saying he was unfortunate he couldn't get to the book party, but wished me well. And there was a very lovely letter that he sent to me, which I always cite after after my speaking engagements. When I denounce the FBI, I'd like to mention I still have some friendly relations with them at times.
But I remember you wrote about his comment. Oh, first you asked him about his grade.
Well, yes, and when in my invitation letter to him, and I said, by the way, when I speak, I often mention that you were a student of mine, but because of your rights of privacy, I never mention the grade you got at my class. And he said in his letter to me, he says, P.S., by the way, I will not waive my privacy rights, thereby giving you a better story to tell.
Oh, you're going to tell us what the grade
was? Can't tell you about the grade.
Maybe you'll tell me privately later. I'd like to touch on one more case before we get into the current very exciting case of challenging the legality of the war in Iraq. And that was your case against the New Jersey State Police in the case of Ron.
It's what I call the case of the long-haired travelers. It was actually the second case on my docket after I started the clinic in 1970. Remember, everything I do is done through my clinic, and my students and I work on these cases together. And we sued the New Jersey State Police in 1970 for what we called conducting a pattern and practice of illegal searches on the New Jersey Turnpike. It wasn't racial profiling in those days, but this was the first police profiling case in the country, but it was profiling hippies. Because it was clear that the
hippies were a great danger to society.
And
long hair was the signature of that.
For the troopers, the issue was if they could find somebody with drugs and make arrests, they would get promotions, they get commendations. It was great for their record. So if they stopped 100 hippies, and if 5 or 6 times they could find some drugs, it'd be great. They had 5 or 6 good busts.
Even though they had no cause for stopping those people.
And there was never any punishment or penalty for making an illegal arrest. So it was a no-lose situation game for them.
Right. So I think they stopped Ron 13 times.
So one of my plaintiffs in that case was a college student going to Rutgers University in New Brunswick at the time. And every day during his junior year, he would drive down the New Jersey Turnpike from his home in Bergen County to New Brunswick. And Ron had a very distinctive appearance. He had long hair down to his waist, a full brown beard, and very sharp piercing eyes.
That was a kind of common hippie look at the time.
Well, that's right.
Maybe a little more exaggerated.
He was very pronounced. And it seems like every time a trooper would pass him, they'd do a double take, they'd pull him over, they'd search his trunk, they'd search his glove compartment, always looking for drugs. They never found anything. So anyway, he became, and then in his senior year, Ron went off to Hebrew University to complete his studies. And while in Jerusalem, there was an American documentary filmmaker making a film. And Ron was always looking for pocket change, looking for odd jobs. He shows up at this film production, And it turns out they're making a documentary on the life of Christ. And they're looking for Roman soldiers, basically. So Ron's in the line, the producer's going down, okay, you over here, you over here. Comes to Ron, he sees the beard, the hair, the eyes. He says, my God, you're Jesus. He made them the star of this documentary film, which actually showed on American television in the early 70s. And so, you know, and Ron, and so, you know, as I always say, you know, this is proof of the old adage that beauty's in the eye of the beholder. This face that to troopers in New Jersey was the face of evil, to this American film producer was the face of the Prince of Peace.
Yeah. In any event, you're now suing the United States government on the legality of the war.
Well, that's right. This case started out against George W. Bush, but it's now called against Barack Obama.
And quite interestingly, just a few weeks ago, on January 24th, this is the New York Times book review section, and they're reviewing two books on this very subject called Who Declares War? One by John Yoo, and the other one by Gary Wills. One from the right, and one from the left, and predictably, their views match their political orientation, which raises some interesting questions. You feels it's perfectly okay for the executive to take over this function. That
John Yoo believes all power to the president.
Right. I think he made a comment, or a number of them at the Bush administration thought that some of the treaties about the Geneva conference, for example, requirements about war, et cetera. I think, how do they refer to it? They're quaint, but obsolete.
Okay. Prohibitions of torture, for example, were quaint.
They're quaint. And Wills, being from the left, is quite appalled by the whole thing. But is the way the Constitution states the division of power and that Congress has to declare war. I mean, is it so vague that there's wiggle room here?
I don't think it's vague at all. If you believe in original intent, in the intent of the framers, there is not the slightest doubt that the founders intended only Congress could declare a war.
Yeah, well, you have it here, if I could just read the first short paragraph of your brief. And you just filed this in
this case
Federal Appeals Court.
Well, the
recently?
case was filed 2 years ago. The district court dismissed the case. We are now waiting argument in the Court of Appeals in Philadelphia. There will be an argument either in late March or in late April or early May. We've just recently had a couple. The court has given us a couple dates, possible dates for argument.
Okay. Well, let's just read what the complaint. Plaintiffs seek a declaratory judgment that the current war in Iraq is being waged in violation of Article 1, Section 8 of the United States Constitution. Quote, Congress shall have the power to declare war because Congress has enacted neither a declaration of war nor an explicit intentional and discrete authorization of war prior to hostilities, because Congress may not transfer its constitutionally mandated duties to the executive, and because the authorization for the use of military force of October 2002 deprived American citizens of the opportunity to vote for or against their elected representatives based on how their representatives voted on the issue of going to war in Iraq, a right protected by Article 1, Section 5 of the Constitution as implemented by the Due Process Clause of the Fifth Amendment. So that seems to be pretty clear. So why is it, you know, by the way, that article in the book review section of the Times points out that that there's a long history of this violation of the Constitution. It cites that George Washington waged war against Native Americans without
it's actually
Congress.
Not quite.
Truman did, Kennedy and Johnson, and now Bush with the Iraq War.
But it's very interesting. George Washington actually told Congress that he could only allow troops to respond to attacks by the Indians. He could not wage war against the Indians without a congressional declaration. George Washington was very clear on that. And for the first 100 years after the founding of the nation, there were two Supreme Court cases, one in 1802 and one during the Civil War, the Price cases in 1862, both of which are very clear that Congress can authorize they make the distinction between all-out war and limited war. An all-out war being invasion of a sovereign country. And the Supreme Court agreed Congress couldn't, only Congress could authorize the invasion of a sovereign country. They could authorize limited hostilities under clear congressional mandates. That was the law up till the Civil War. Mm-hmm. After World War II, during Korea, Vietnam, the law gets cloudy, but no court has ever really looked at the actual constitutionality of it. They avoid deciding the cases on the various technical grounds, jurisdictional grounds. They call it no standing, no justiciability. But no court since 1862 has ever really tried to say what Article 1, Section 8, Clause 11 of the Constitution means. That's the last time the Supreme Court ever actually interpreted that section. Since then, they have avoided the issue, and the purpose of our case is to try to get a court to confront what the original intent of the framers was. Now, we say it's clear. If you're going to invade a sovereign nation, you need a declaration of war by Congress. It's what Thomas Jefferson, remember, Thomas Jefferson was not at the Constitutional Convention in 1787. But after they came out with this clause, Jefferson wrote to Madison and congratulated the convention for chaining the dog of war. He says, you have taken away the power of the monarch, the president, to launch a war. Only Congress can do it. Jefferson was ecstatic over that clause in the Constitution.
So tell me this, Frank. So why is it, and we have all these citations now of wars that have been waged in violation of this provision of the Constitution, why is our current Congress so passive about this? Why aren't they yelling and screaming and saying, hey, you're stealing what is our right, our legal right, according to the way it's stated clearly in the Constitution?
You know, it's interesting. George W. Bush claimed that in October of 2002, Congress passed something called the Authorization of Use of Military Force Against Iraq. Now, that authorization seemed to give the president discretion to do something without time limit. Whether it was 10 years or 20 years, it sat there. 6 months later, George Bush went to that AUMF and claimed Congress had authorized his war in Iraq. Now, during the presidential primary, you may recall, Hillary Clinton, who voted for that AUMF, and Joe Biden, who had voted for that AUMF, both said, well, we didn't intend to give Bush the power to invade Iraq. That was just an authorization to conduct negotiations, to check if there were any WMDs, to go to the United Nations. We always thought he would have to come back to Congress for an actual declaration. So, what the problem is, Congress, in a sense, evades its responsibility. And they let Bush Bush says, Congress told me to do it, and Congress says to Bush, well, we didn't tell you to do it, it's your fault. So when the war goes bad, they want to blame each other.
Yes.
Congress doesn't want to take responsibility. They don't want to take responsibility.
There's another view that I've heard that I'd like to get your reaction to, that Congress is allowing this to happen because basically they support the war, but they would prefer that it be the president's war so they don't have to go back to their constituencies and defend the decision to go to war. So they feel that it's good for their electability, and that's why they're kind of closing their eyes or acting passive.
Well, of course, every congressperson, every senator has their own, view of this, and they may have their own. Each one has their own excuses. And who knows? Some of them were opposed to the war, some were in favor of the war, but didn't want to go on record in support of it. So they did. They ducked as a body, they ducked the issue.
They're ducking the issue. What about the public? Why isn't this much more of a public outcry? There, too, I heard one view that not only in the present situation, but that historically the public always looked the other way on these constitutional issues when fear was rampant. At one time, we were worried about the atomic bomb and being attacked by Russia, and now we're worried about terrorism. And that some commentators have said that typically gets the public off the case, and they just say, "Protect us," and we don't care about the Constitution. Just protect us.
Well, when the public turns against the war, then Congress turns against. I mean, that's what happened to the war in Vietnam, right? Everything was fine. You know, Congress gave the appropriations. They let it go on till the country got fed up with it, and suddenly Congress said, "Let's get out of here.
Yeah.
We don't want it anymore." The same thing with Iraq. As long as mission accomplished and everything was fine, the public was behind it. Congress was happy. Things started going badly. The Iraq war became very unpopular. And Barack Obama was elected president probably because he opposed the war in Iraq to begin with. It became an unpopular war. So, but the members of Congress are always looking over their shoulders. What are we supposed to do?
Interesting case. Where is it going to go, Frank?
Well, right now we're waiting for an argument in the Court of Appeals in Philadelphia. Say that'll be sometime in April or May. And we'll see. If we lose there, we'll try to go to the U.S. Supreme Court and get the U.S. Supreme Court to finally face up to this question.
But going back to a comment you made earlier in our discussion, given that the Supreme Court has a conservative leaning right now, and that these decisions seem to be more political than constitutional in terms of law per se, that doesn't bode well.
Well, it doesn't bode well, but let me tell you, see, Justice Scalia, who's the arch conservative, is a great advocate of the original intent of the founders. And this is an original intent case. Scalia should be on our side, because there really can't be any real debate of what the founders intended here.
Well, Frank, lots of luck with that. I'd like to end, though, on a story, another one of your stories about the FBI. And this one, at least the conclusion of this experience that you had, is that it may not be all that bad to have an FBI dossier. Well, I'm talking about your 25th anniversary celebration.
That's true.
We'll have to do this rather quickly because we're going to have to sign off.
Right. On my 25th anniversary, my wife put me in a car and started on a mystery car ride. And it finally dawned on me when we got to a sign saying Harrison, New York, she was tracing the path of our elopement. And we remembered we'd been married by a justice of the peace named Venezia, and we were looking around town trying to find his home. We looked in the telephone, but there was no evidence of a Venezia. 6 months later, when I'm writing my memoir and I have my FBI files in front of me, I found the answer. We were married by Justice Venezia at his home in 6 Calvert Place in Harrison, New York. It was in my FBI files. They come in very handy at times.
Yes. So, folks, if you're writing your memoir, get your FBI file. It might help. Okay. Frank, I want to thank you for being here today. This is it. It was fabulous seeing you again. Frank and I are old friends, actually. And good luck with your suit. I think it's an important principle to establish. And I want to thank our audience and to invite you back in 2 weeks for another edition of Access for All. And for Access for All, I'm Dr. Bernard Starr.